We've set the entire firm up from the ground up. We've built it around focusing on client outcomes. A lot of law firms sort of start to treat clients more as a numbers game. Quite a lot of firms tend to take the attitude of the big banks, which is almost they're doing the client a favour, when really it's the reverse. It's, the lawyer should feel privileged to be acting for the client and to be able to provide them with services. We don't want to be seen as a traditional old legal firm. We want to be seen as a modern firm that embraces technology, that has a focus on being friendly in the way we deal with our clients. So it's all about breaking down that traditional mystique and focus on generating positive experiences for our clients. So Buddy Legal specialises in personal injury cases and negligence cases, and what that means is the cases we do are motor vehicle accident claims, medical negligence claims, workers' compensation claims, criminal injuries compensation claims, any sort of a claim where a person has sustained injury as a result of the fault of another person. We also do negligence claims where there isn't injury involved, but it still is based in the tort of negligence. So that's where, for example, someone's had a house built and the architect has drawn plans which are faulty and require the building to be rebuilt or amended or have some works done to it at the expense of that client because the professional at first instance didn't do it right. But the bulk of our work is personal injury claims, but in essence we do any claim which involves the tort of negligence. That's where our skill set lies. Our firm is a specialist firm. We only do this, but we do it well. So we don't try and spread ourselves too thin. We're a master of our trade, not a jack of all trades. So one of the biggest problems that clients face is really this mystification of law. Law isn't this sort of magic black art that some lawyers would have you believe. It's really just a process that we go through, and one of the things we do to try and help clients understand where their case is at and where it's going is by giving them a portal, so at any time that they can access their case and see what's been done recently and what might be waiting, what the lawyer might be waiting for in terms of progressing the case forward. So at any time they can log into that and see what's happened recently and what is to, what they might be waiting for from there. Ensuring clients understand things means that costs are kept down, means that the quality of work is at its best. The computer system that we've set up are designed to enable us to do work efficiently and effectively to reduce the overall cost of the claim by training our lawyers to target what's required for a case and not spin the wheels and simply not progress a case. By targeting that issue, we also help ensure that there's no wasted costs on matters. The law has been lagging in terms of adopting changes. There's no doubt about that. You've got these fancy big offices with actual books and things like that in there, which this day and age there just isn't a need for. The reality is that most lawyers access the law online. Some of the firms continue to remain in that sort of archaic mentality. So law has been a slow industry to adopt technological advances, and it still remains slow. But one of our focuses with Buddy Legal is to really embrace technology so that we can deliver the services as quickly, as efficiently, and with as much quality as we can. I get a real buzz out of the technological side of it, so I really enjoy setting up these cloud-based systems. So in fact, the lawyers can work from anywhere, they can work from home, they can work from overseas, setting up these processes so that the case will run so long as the lawyer and or the client has access to the internet. And the systems that we use are at the forefront of technology, and we've got a big focus on technology in that regard because we truly believe that it enables us to deliver better quality work for our clients. So that we can ensure that the lawyer explains the case properly to a client, we only employ lawyers with at least 5 years experience in litigation. Our lawyers have a really good grasp of the litigation process because that means when they have that inherent understanding, they can explain to the clients what they're in for and address the issues as and when they arise. We're really committed to making sure that clients understand how their case is progressing. If a client doesn't understand that, that then leads to concern on the client's behalf. So we're very committed to reporting regularly to clients. And in fact, if a client lacks an understanding in relation to a case, whether they've got why they're seeing a particular doctor or what's happening in relation to a court process, then they're completely entitled to call their lawyer directly and ask them what's going on for free. So the lawyer's not allowed to charge them to explain to the client what's happening in relation to their case. One of the other things we do is we make sure that the clients have the lawyer's direct contact. We don't want a situation where they call in to speak to their lawyer and some secretary answers it, or someone who doesn't have an understanding of their case. So we give each of our clients the direct telephone number for their lawyer. So unless the lawyer's in court, in a meeting, or unavailable for some other reason, they know that the person that they're going to be speaking to is their lawyer, who understands where their case is at, what needs to happen, and can answer their questions. So there's no fobbing clients off to secretaries to take messages, when they return to the office. We will not allow our lawyers to speak in lawyer speak. Notwithstanding that I'm kind of doing that now, but no, we won't allow our lawyers to speak in lawyer speak at all. And the reason for that is there just isn't any need for it. It's a remnant of when the law used to be this black mystic art, and that's gone. It's a service that we provide to people, and quite frankly, there is no need whatsoever to use fancy language. In fact, there is a need to use plain, simple language to ensure that clients understand what's happening with their matter. So lawyer speak, it's a big no-no. The law does change, it's continually evolving. There's literally probably 1,000 different variables that are involved in any case, more than 1,000. And each of those variables tend to be developed little bit by little bit. And so the lawyers need to not only stay on top of the case law as it develops, but also stay on top of legislative changes that are made by Parliament. And there is a need for the lawyer and the firm to make sure that it stays on top of those changes as the law evolves. It's not a sausage factory like some lawyers would try and treat it. The fact is that each case is unique, and there is a need for the lawyer and the firm to make sure that it stays on top of those changes as the law evolves. Basically, we offer a free, no obligation initial conversation to inquirers. And the purpose of that is we want people to be able to call us if they have an issue in relation to a claim, whether they simply want to find out if they have a claim, or if they have a claim, how much it might be worth, if it's worth their time to progress it. And so we encourage people just to simply call us, and we encourage them by doing that, by offering it as an absolutely free, no obligation service. They can just give us a buzz, we can have a chat about their issue, and we'll give them our genuine opinions. For cases with merit, we offer a no-win, no-pay situation. A lot of lawyers will offer no-win, no-fee, but no-win, no-pay is even better again, because what it says is that not only if you lose, we won't charge you, but we also say that if you lose and you have to pay costs to the other side, we will indemnify you for those costs as well. So we actually put our money where our mouth is. We're not saying you're not risking any money when you progress forward. We'll make sure that we'll cover you for that and indemnify you for that. So there's no risk to the client in relation to progressing forward, provided obviously we believe it's a case that's worth progressing and has merit. So they don't need to worry about committing to a case and then potentially being out of pocket tens of thousands of dollars to the other side. So that's the difference between the no-win, no-pay and the no-win, no-fee. No-win, no-fee is simply they won't charge you, or the lawyer won't charge you. But we do that step further. We will not charge you, and we'll also indemnify you for any costs that you might owe the other side in relation to the claim. So long as you get the evidence so that you can prove to the other side that your losses are X, that your chances of success are Y, then you can almost ensure that a matter can be resolved by mutual agreement between the parties. Because if they know that you're going to go to a court and that you're likely to achieve this outcome, then they'll make offers that are commensurate with that. So the focus for the case should always be about the evidence, particularly for personal injury claims. It's It's about getting detailed evidence, because that evidence then means that the other side will come to the party. If you don't have that evidence, you might think or may even know that it's worth a particular amount, but the insurers or the defendant is never going to pay that until you give them that proof. So the focus must always be about developing the evidence so that you can give it to the other side and say, look, come to the party or we're going to go to trial. The value actually has little play in terms of how you run a case. At the end of the day, it almost doesn't matter if it's a $2 million case or if it's a $20,000 case. The processes that are involved in that have a lot of commonality, and it's not hard for us to deal with a $2 million claim or a $20,000. How you deal with that is obviously differently, because you're not going to go and get 16 different medical reports for a $20,000 case, but you might do that for one which is worth $2 million. But the fact is, we deal with the cases from small to large. We won't take on cases where we don't think we're going to add value. So if a claim's worth $3,000 and we think that our legal fees are going to be $5,000, we're simply not going to take the case on, because we're not going to be adding value to the client in that situation. So we won't do the small cases. When I say small, I mean really small. Paper cuts and things like that, they might technically have a claim, but we're not going to take those on. We'll only advance claims where we think that we're going to add value, both in terms of improving the quantum, or the amount of damages that a client receives, and also in terms of removing the administrative hassle that clients go through. It's quite a confusing and complicated process, and there is value that a lawyer gives in removing that stress from a client. So quite often I'll say to a client, look, with a small case, they'll come to me and say, we want you to act for us. And I'll say, look, the claim might be worth about $10,000. Out of pocket, it's going to probably cost you about $3,000 for your legal fees. You might be able to achieve $7,000 yourself, so you might be on par. And you may as well go off and do that, so I recommend you do that. But the client will say, well, look, I don't really know how to get a medical report. I don't know who to get a medical report from. I don't really know how to fill out this form. And you know what? I'm busy. I've got my own life to get on with. And so in that sense, I want to engage you anyway. So they're happy to sort of, engage us on that basis. But as I said, if we can't add value either in taking away the administrative burden and or in relation to improving the quantum outcome for the client, we won't take it. Attitude of the lawyer is all about focusing on the client's needs, which means making sure the client understands where their case is going and why it's going in that particular direction as well. And I find that if you can address that, clients tend to be much happier people, and that understanding removes the fear associated with the process, because claims are obviously a fearful process for clients to begin with, and we don't want to add to that. In fact, we want to do the opposite to that. We want to actually make clients feel as relaxed about the process as possible. So that's one of the key points of differences with us.